Audio calls from where?
From the jail.
All right, so, I mean,
Letters from the jail, changes with the autopsy.
all right, with regards to calls from the Bear County Jail, the state, if they're monitoring calls, then they give those to you as soon as they get them. I'm not going to allow for a continuance, just so everybody knows, based upon jail calls that your client is making.
No, I'm not asking for that. I didn't even mention jail calls in there. I'm just telling you in terms of what's going on that I hadn't, when I did this motion, I hadn't received anything from the state at all. Your Honor, you, as I recall, we're here for 3 weeks and I got, Judge Harrell did an interim discovery approval with the autopsy and medical examiner of state agreed, Mrs. Mitchell at that point. I'm having some difficulties with the medical examiner. The original person is in Corpus Christi. So, and then the state had an interview with her first name is Kimberly. I don't remember the last name of Molina. Thank you. Dr. Molina, and she has an interview that the state has also provided me with this week, but vast changes.
All right, so I bring up the audio calls because you mentioned that you were continuing to receive audio calls from the state. And then you informed me that those were jail calls. That's why I brought that up. So everybody knows jail calls that your client is making, I'm not going to grant, and I know that's not in the motion, but I want everybody to be aware. I'm not going to grant a motion for continuance based on the fact that maybe the state is recently getting jail calls that your client. Texas versus Jose Ruiz. And does anybody have the motion for continuance?
This is the one with the, excuse me, with the affidavit signed. When I scanned it for the email, I couldn't, my scanner was broken.
That's okay.
But
So can I
that
have
actually
parties?
has the affidavit.
All right, can I have parties announced for the record for the state?
Marissa Giovanco for the state.
Defense?
Teresa Connolly.
Randy
Mr.
Fern.
Reese.
All right, defense has filed a motion for continuance for a trial date that is set October 3rd.
Yes.
State, are you ready to proceed on the motion for continuance?
We are, Judge.
All right, let me read this for one moment, please. All right, so there's some matters in the motion for continuance that the court's recollection is completely different. For example, when anybody requests that an attorney be appointed to sit with them, I allow it. So there's your motion that you said that since Lorraine Ephraim was well acquainted with this case and willing to be of assistance, Teresa Connolly requested that the court reappoint her. The court denied that request. Lorraine Ephraim was later reappointed through the MAC. As all parties know, they have stated that judges necessarily do not just look around the courtroom like we used to before and say, hey, can you get on this case and help out? It has to go through the managed assigned counsel. So whenever, and I think Ms. Ephraim is aware that whenever someone requests a second, I always give them, unless there's some strange reason why they have not, where I feel they don't need a second, but it's felony court. So I'm always, I don't want to say always, because there may be exceptions, but no exception has ever appeared before the court since I was on the bench where I wouldn't allow somebody to have a second attorney. So with regards to that in the motion for continuance, the court is not in agreement with that statement, but you are asking for a continuance, but because you're saying that you need more time.
Well, and I think one of the issues with regard to that, raising that point, is that there's just so much disruption in this continuity in representation. So even though I was initially appointed, then I was replaced by a retained attorney, and then back on, I lost we lost so much time there. And our defense team lost time there. So it's, we're trying to get it back to where we could have been if we'd stayed on from the beginning.
This, Your Honor, this packet right here is the original discovery. It's 1 inch thick, taken down from the discovery that we get from the state. In addition to that, there are 2 terabytes. I just gave Lorraine the 2nd terabyte that I picked up earlier in the week. In addition to that, every single day we're getting new things, audio calls. This is incredible. The amount.
Audio calls from where?
From the jail.
All right, so, I mean,
Letters in the jail, changes with the autopsy.
all right, with regards to calls from the Bear County Jail, the state, if they're monitoring calls, then they give those to you as soon as they get them. I'm not going to allow for a continuance, just so everybody knows, based upon jail calls that your client is making.
No, I'm not asking for that. I didn't even mention jail calls in there. I'm just telling you in terms of what's going on that I hadn't, when I did this motion, I hadn't received anything from the state at all. Your Honor, as I recall, we're here for 3 weeks and I got, Judge Harrell did an interim discovery approval with the autopsy and medical examiner, state agreed, Mrs. Mitchell at that point. I'm having some difficulties with the medical examiner. The original person is in Corpus Christi. So, and then the state had an interview with her first name is Kimberly. I don't remember the last name of Molina. Thank you. Dr. Molina, and she has an interview that the state has also provided me with this week, but vast changes.
All right, so I bring up the audio calls because you mentioned that you were continuing to receive audio calls from the state. And then you informed me that those were jail calls. That's why I brought that up. So everybody knows jail calls that your client is making, I'm not going to grant, and I know that's not in the motion, but I want everybody to be aware. I'm not going to grant a motion for continuance based on the fact that maybe the state is recently getting jail calls that your client has made. So are you going to object to this motion for continuance?
Judge, we're not in agreement to the motion. I don't know that we are formally objecting to the motion. There's a lot in the motion and we understand that there is a lot of discovery in the case. I would object to a 9-month continuance. Absolutely. I think that is what defense is asking for. And I think that is.
No, there would not be a 9-month continuance.
We would object to that for sure. We are ready for trial as is, Judge. And I disagree with defense's statement that prior to the motion, she did not receive any discovery. A external hard drive was given to Ms. Efron. We've been turning over discovery nonstop, and the recent stuff has been jail calls and mail that we are in constant collection of. I also will say there was a statement by defense counsel about changes to the autopsy. There were no changes to the autopsy. We did interview a different medical examiner who may have had slight differences of opinions, and we turned over our notes, which arguably are work product, but we did turn those over. In an abundance of caution, we've turned over all of our notes from our meetings. And so there's not really changes to the autopsy, but a different person is going to testify for the state as far as a medical examiner, because defense is correct. The original medical examiner no longer works for the Bear County Medical Examiner's Office.
All right. So with regards to.
Just with regard to the voluminous discovery, I mean, some of the CPS records that the state has turned over amount to over 13,000 pages. Yeah.
All right. So with regards to CPS records, court has done a lot of CPS cases. A lot of those are duplicates. I'm bringing this case back on October 23rd. And on that day, everybody needs to have their discovery. This case will be tried before the new year. All right. And I will orally grant your motion for continuance, but I'm not going to sign your motion for continuance because there are things in there that the court is not in agreement with. So orally, I will grant your motion for continuance. We're coming back on October, did I say October 23rd?
23rd, Judge. If I may, as I am in multi-roles, if I can just check my calendar real
Sure.
quick.
And that would not be a day you would expect witnesses here.
No, October 23rd is just for everybody to have all their discovery. And when we come back on October 23rd, this is going to get a jury trial date.
Oh.
And it's going to be before the new year.
Okay.
Thank
Okay,
you,
that's
Judge.
not a jury trial date then.
No,
Okay, I misunderstood. Okay, thank you, Judge.
all right,
There's one letter of support, I would like to submit support from her daughter.
okay. All right, who is the prosecutor on this case? They know. Yeah. All right, court is calling 2023 CR 5382B. I'm sorry, what? Hi. There's a lot happening. So everyone, this is what we're going to do. When we're on the record, don't approach the court coordinator because they're too close. If you want to approach the deputy and have them bring your person out, you're more than welcome to do so. Court is calling 2023 CR 5382B, State of Texas versus Elsa Morales. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Glenn paying for the defense.
And are you Miss Morales?
Yes, Your Honor.
All right, you entered a plea on August 14th. You entered a plea of guilty, applied for deferred adjudication. The state is asking that your punishment be assessed at 1 year in the state jail facility. They're remaining silent on your recommendations and they're taking certain cases into consideration. Have both parties had a chance to review the PSI report?
Yeah, there actually wasn't a PSI created in this court. You asked to reset. We asked for the PSI to get the letter, then you just wanted to see the criminal history.
Yes. So is there criminal history available for the court? Thank you. Okay. All right, the court has reviewed the criminal history. Defense, do you have any witnesses?
Judge, no witnesses, like I said, we just had one support letter on behalf of Ms. Morales, it's her daughter, stating how she helped, that Ms. Morales helps take care of children, and she was working at a home health care. Also supplied money for the family. We're gonna ask that the court grant her probation in this case. And let her continue support of her family.
All right, Ms. Morales, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Elsa Mireles.
All right, why are you stealing?
That was a bachelor. I wasn't thinking.
Why are you involving a child in theft? Because it says that this was the MO, go to the store, put things in a cart, and then have a child push the cart outside. So you're basically unwittingly making a child a criminal. Why are you doing that? I mean, your attorney was not there, so he can't answer this question. You did it. You took a child in Target, or as we say, Target. You took a child there, loaded things in a basket, and for that child to know to just push that cart towards all points of sale tells me that somebody told that child, this is what's going to go down. We're going to go in, we're going to put items in this cart, and you just keep pushing it. So why?
I have no words for that.
Yes, and how old was the child that you all involved in your criminal activity who now thinks it's okay to engage in criminal activity?
5 years old.
All right, so you took a 5-year-old, and what day of the week was this? Monday, Tuesday, Wednesday, Thursday, Friday, Saturday, Sunday, what day?
I'm not sure.
Right. Was it a school day?
No, I'm not too sure.
All right, so you take this 5-year-old, walk me through it. So the 5-year-old is pushing the cart out, and obviously police are called, right?
Right.
And did they speak to the 5-year-old? What is the 5-year-old thinking? Do you know? I know somebody will probably object to speculation, but I just want to know, what was the 5-year-old doing when police are there? I'm assuming you all were placed in handcuffs.
I was already in the car. It was with his mother.
Mhm. All right, so it was you and his mother who was stealing. Is that what you're saying?
We were already out and the mom told him to leave it there and he did it.
I'm sorry, I can't hear you.
Somebody else helped the little boy push it out.
All right, so someone helped the little boy push the cart out after you all were committing a theft from Target. And what items were you all taking?
It was stuff for the kids.
No. Don't put this on the children. What items were you taking?
Toys.
And what else?
It was clothing.
So you're teaching children that in order to get things, they should steal. That's what you're teaching. And you left out to the tune of $553.69. So how full was the cart that you were taking out?
It was full.
All right. And then now I've received this letter where you took a child to help you steal, and somebody is saying that you're taking care of children and you're a home health care provider. I don't allow people in this courtroom who are on probation to be home health care providers. And who are you providing health to? Is this a relative?
No,
Right. So I don't know how you're able to take care of children and be a home health care provider.
those are my kids that I take care of.
Mhm. I don't think you're a good candidate for probation because it appears that your background is littered with theft cases and you're here on a theft enhanced. And how old are you?
43.
I mean, you're old enough to know better. It's not like you're 20 or you're 19 and you have peer pressure. So again, tell me, why are you stealing? It says here that you have a job, that you can pay for things. I don't
I
understand
didn't have
the
a job
stealing.
at that time, Your Honor, but that doesn't excuse for it.
I'm sorry, what?
I didn't have a job at that time, but that doesn't excuse. for it.
And it certainly doesn't excuse involving a 5-year-old in your criminal activity. So again, why should I give you probation? The state is silent. Why should I give you probation?
Because I gotta take care of my kids. There's no fathers involved for my children.
Well, when you were using the 5-year-old to steal items, were you thinking about, who's going to take care of my children if I am at the Bexar County Jail? Were you thinking about that?
No, Your Honor.
And if something would have ended up happening, sometimes when people go to places and they steal, sometimes people end up getting shot. If that 5-year-old would have been shot, you know what would have ended up happening? You would have been on somebody's news, boo-hooing and crying about how it's unfair that your child was shot. So what am I supposed to do about this? You won't stop stealing.
I will, Your Honor.
Now, did you say that to the last judge, that you were going to stop stealing? How many times in your lifetime on this planet, as a 41-year-old, have you had criminal cases for stealing? Now, mind you, name them all because I've read the report.
Like, I believe 5 cases.
And you have not learned anything from that. What you've learned, obviously, is to continue to steal and start this idea where you take a child in with you, you put items in a cart and you just have them pushing it out. In my mind, I can imagine this 5-year-old, because when you see children pushing carts, they're not even old enough to stand and look over the cart. They're just struggling, barely pushing it. And I'm always thinking to myself, why doesn't a parent help that child push their cart?
Your Honor, we told him to leave it there and he continued pushing it out. That's when the other 2 people helped him.
Oh, so now you're saying
Yeah, that's what we did.
you did not include him in your criminal enterprise.
We told him to leave it there and the other two people, random people, helped him.
Oh, so this is not a theft case. You were not intending to have him steal. Is that what you're telling the court?
That's what happened.
No, no, no. Are you telling the court that this was not a criminal enterprise, that you or somebody loaded a cart at Target with items, the 5-year-old was pushing it, and you're continuing putting items in a cart totaling over $500. And then as he's pushing the cart past points of sale, you're telling him, oh, just leave that there. Maybe you're telling him, we don't have money for that. We just loaded up the cart for some unknown reason and we have no money for that. Is that what you're telling the court? If not, let me know. I mean, I wasn't there, state wasn't there, your counsel wasn't there. I'm just trying to figure out if that's what you're telling me. If that's not what you're telling me, say, judge, no, that's not what I'm telling you. I'm not going to take that as a sign of disrespect, okay? So are you telling the court that you all loaded up a cart of items at Target? The 5-year-old is pushing the cart and you're telling the 5-year-old, leave the cart there. We don't have any money for these items. And your intent was just to walk out. Is that what you're telling the court?
To walk out without the stuff, like to leave the stuff there.
Okay. Is there anything else?
Judge, with this testimony elicited from my client at this time, I think we need to ask the court to withdraw her plea.
All right, that'll be denied. All right, this is what the court is going to do. Court is going to find you guilty. Court is going to sentence you to 1 year in the state jail facility. Give you credit for any time served. Take in consideration GJ 812055, JN number 2127782. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, I did.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. 2021 CR 10657, State of Texas versus Jose Alonzo Ramirez. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Frank Maurer for Mr. Ramirez.
All right. Do you have any objection to this attorney standing in for Robert Maurer? Do you have any objections to that? Are you okay with this attorney?
Sir, I mean, yes, ma'am.
Are you okay with this attorney standing in for Robert Maurer? All right. State, do you have any objections to this attorney standing in?
No objection, Your Honor.
All right. And are you Jose Alonzo Ramirez?
Ma'am.
Going to show you what's entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Jose Alonzo Ramirez who was placed on community supervision in 2021 CR 10657 for the offense of terroristic threat of a peace officer on January 26, 2022 for a term of 2 years? Is that you?
Yes, ma'am.
State?
Violated condition number 4 in Bexar County, Texas. The defendant, Jose Alonzo Ramirez, did then and there fail to report to the supervision officer as directed for the months of September, October, and November of 2022 in violation of condition number 4.
How do you plead to that? True or not true?
Good.
I'm sorry?
True.
State?
Your Honor, we waive the other violations alleged in the motion.
Any objections to the waivers?
No objection, Your Honor.
All right. Did you understand by pleading true to violation of condition number 2, court could find it true, grant the motion, sentence you to 2 years in the state jail facility and up to a $1,500 fine. Did you understand?
Yes,
Knowing that, do you still wish to plead true to violation of condition number 4?
yes,
Court will find violation of condition number 4 true. Is there an agreement?
There is, Your Honor. We're asking that you deny the motion, extend the defendant's probation for 2 years, alter and amend the conditions for a TAP evaluation while in custody, for intensive outpatient treatment, with bi-weekly drug tests for 90 days and random thereafter. We're asking the defendant to take the BIPP course and verify his residency and employment every 90 days. Judge.
What has he done on probation? Other than not reporting? Probation? Has he done anything since he's been on probation?
Or he's made a payment toward his fees of $100. He did complete the drug court evaluation. He did not qualify. Other than that, Your Honor, no other terms of probation have been satisfied.
I'm not inclined to follow your agreement because you haven't done anything. You haven't reported. Why have you not reported? You want to raise your right hand? You solemnly swear affirm the testimony you give will be the truth, that nothing but the truth so help you God.
Yes, ma'am.
You can lower your hand, state your name for the record.
Yes.
State your name for the record.
Alonso Ramirez.
All right, why have you not reported?
I was talking with Zoom, my PO. He never told me nothing about. I was reporting with the Zoom. That's it. I was keep calling them many times when I was working out of town. And I was, then when I went to report, I said,
No, they're saying you have not reported.
I was talking to Boss, that's my probation officer.
All right, I'm telling you both, I'm not inclined to follow this agreement. He has not reported. To me, that's the easiest thing. So if you would like, the most I can sentence you to is 2 years in the state jail facility. I'll sentence you to 1 year.
1 year.
Mhm. Would you prefer that?
Yes.
All right, if you'll grab the trial court certification form, please. All right, the court is going to revoke, sentence you to 1 year in the state jail facility, give you credit for any time served. If you would like the therapeutic community, I can request that for you. It doesn't increase the length of time that you've been on, that you would serve. So for example, since I'm sentencing you to 1 year in the state jail facility, if you're in the program for therapeutic community, if you haven't completed their program, they're not going to say, oh, he's due to get out. But since he hasn't completed the program, we're going to continue him. It's completely up to you. So would you like for me to have you referred to the therapeutic community or no?
Yes.
All right. So I'm going to request the therapeutic community. Even though I'm requesting it, you're going to have to request it as well, because I don't have the jurisdiction to force them to place you in the program. You understand?
The courtroom turned deadly silent. Pete Garcia begged for probation, talking about jobs and family. But the judge focused on the victim's trauma, not excuses. Accountability finally caught up. With one cold decision, the judge denied probation and sentenced him to 8 years in prison.
All right. Any objections to the waiver?
No, Your Honor.
Did you understand by pleading true to violation of conditions 1 and 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violations conditions 1 and 1?
Yes, Your Honor.
Court will find violations 1 and 1 true. Is there an agreement?
There is, Your Honor. The defendant has agreed to state ISF, Judge.
And that is the agreement, Your Honor.
Is this just state IS cognitive?
It is, Judge. We checked a couple of days ago, I believe it would be a 40-day wait inpatient and I believe a 90-day inpatient after that. So he's aware that he's looking at a commitment of 130 days.
All right. And is he eligible for state ISF?
Your Honor, he will be. I forgot to mention. He pled true to these 2 violations. With the state is going to TIC the underlying.
All right. And what are the cause numbers?
You
You can cover them.
I've got them for you, Hank.
Oh, thanks.
Your Honor, one of them is 714734.
Mhm.
The other one is 714735. They were both out of the same incident.
All right. The court will find violations of 1 and 1 true. Probation, are you in agreement with this recommendation?
Yes,
All right. The court will deny the motion, alter and amend conditions to include state ISF cognitive, taking consideration 714-734 and 714-735. Mr. Armstrong, is there anything else you need from the court so you can obey the rules and be a productive citizen?
May I speak on his behalf, Your Honor? He
No,
was,
I want to know if there's anything else he needs.
Oh, yeah, there's one thing, Your Honor. It's
Yes.
just if I may be able to attend church again.
Oh, no, we're not even at that point. We're at the point where you're on deferred adjudication. You're looking at 20 years in prison and you picked up 2 number ones. So what I'm trying to figure out is what is your thought process that you're not thinking and it's not at the forefront of your mind that you could be doing 20 years in prison? I'm sure your attorney has spoken to you about this. I don't take any joy or pleasure in sending people to prison. When I place people on probation, I'm hoping that they're going to be successful. I want them to be successful. I want them to turn their life around. I don't want them to come back before me unless they're coming back before me to say, I've learned a lot. You'll never see me again for this. You understand?
Yes, Your Honor.
So I'm talking about in terms of that. Is there anything else you need from the court?
No, Your Honor.
All right, then I'll sentence you to state ISF cognitive, taking consideration 714-734 and 714-735. Once you're released from state ISF, you need to immediately contact your probation officer. Do you understand?
Yes, Your Honor.
All right, we can go off the record from here on out. Everything that you do, you need to ask yourself 2 questions. 1, is this something that could potentially result in me going to prison for 20 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. You understand?
Yes, Your Honor.
All right, good luck to you. Always good seeing you, Mr. Powers.
thank you, Judge.
No, my birthday is November 2nd, so you didn't miss it.
Always remember that stuff better than I do.
All right, are the attorneys here for Luis Cordero, Michael Herrera, Eric Johnson, which I have the note, so we're waiting for that attorney. Eric Gonzalez Lopez. All right. Do we have the interpreter?
It's not for an interpreter.
All
but
right.
I don't know that-
Could you call down the interpreter, please?
Yeah, he's here. I didn't realize too. I was recently appointed, so.
Yes. No, he needs an interpreter. So,
So every time I need to ask for an interpreter.
mhm.
Okay, now I know.
Okay. All right, counsel. Do you speak Spanish?
Do I speak Spanish?
Yes.
Yeah, okay.
All right, bring your client up. The interpreters are all
I
out.
needed one.
No, I always make the announcement. All right, so he's already had an immigration attorney appointed to him, and that was Teresa Cozdobla. So he should have already received a report because she was appointed in February.
I was recently appointed to the case after Raymond and Victoria got off the case.
No, what I'm
So
saying, he has immigration issues.
I'm perfectly capable of dealing with his immigration issues,
right.
but I will get with whoever they.
Well,
have.
she's already, my understanding, she's already done a report. I'm just giving you an update.
Oh, okay, I got you.
So that was done in February. This case has been lingering since January. So, and I know you were recently appointed, so I'm going to give you a chance to get caught up on discovery if you need a chance for that.
Please, and I did confer with the state. There is evidently a massive amount of discovery that I'm going to try to get from Raymond because they gave him a hard drive, or I guess one of those terabyte hard drives that he got everything on. So I'll get with him, see if he'll go ahead and just give that to me and I'll trade him a blank one for it.
Mhm.
I know that they are also transcribing interviews. So that's something that the prosecutor let me know that they are still working on, that it's not been completed yet. But I'm just gonna get caught up, Judge. I will let the court know that I have a quote unquote vacation coming up because I'm gonna be in Comal County in a capital murder case for a couple of weeks.
Okay.
Great vacation.
All right, when is that?
That October, it's gonna begin October 6th and it may run into the second week. They do things very differently from here. So their trial is every day, all day. So
Okay. All right, Ms. Ferguson, on Eric Gonzalez Lopez, recall this for 60 days.
And Judge, I did inform defense if they were unable to get the discovery through prior defense counsel that we can make arrangements for them to drop off.
Yeah,
All right, so that needs to be done
absolutely.
before next week is concluded.
I'll either get it from Raymond or I'll drop off a hard drive of my own.
All right, what date? All right, November 13th.
Thank you, Judge.
You're welcome. And if you'll let your client know, please.
Okay.
Yes. Are we ready on Luis Cordero?
Yes, we are, Judge.
And he's only pleading to one case, correct?
Yes.
All right, where's Mr. Cordero? Court is calling 2022 CR 6145 State of Texas versus Luis Francisco Cordero. Can I have parties announced for the record for the state?
Daniel Escobar from the state of Texas.
Defense?
Robert Gowan for the defendant.
Are you Mr. Cordero? Counsel, have you received all the discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Are there any applications in this case?
No, Your Honor.
All right. Mr. Cordero, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes.
Do you understand it, Mr. Cordero? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Mr. Cordero, I'm showing you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of fraudulent use or possession of identifying information, 5 items or less, as a state jail felony? The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Your Honor, it was supposed to be on the Burglary building. Unless the paperwork-
I have the wrong paperwork.
Is the paperwork-
I
Right.
received a 6145.
All righty. Let me see. Yeah, this says 6145 on here. So if y'all want to change that number and you're proceeding on 2020 CR 3591.
That's correct, Judge.
Okay. That's no problem. It happens. Can I have a file stamp, please? Thank you. Oh, no, I just need a file stamp. Yeah, we're good. Thank you.
I just would like to get in.
No problem. It happens.
I just guarantee you I'll probably just read the first one.
Okay.
Thank you.
All right. So did you understand you're charged with the offense of burglary of a building? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Cordero, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to. The court will find that defendant has knowingly and voluntarily waived and consented to stipulations. No, just 1 second. I'm reviewing the paperwork and there's an issue with the paperwork. Everyone, just give me a moment, please.
Sure.
This bond hearing exploded with tension. Guns, robbery allegations, and disturbing photos shocked the courtroom. The defense tried to spin the story, but the judge stayed ice cold. Public safety came first. Bonds stayed high, restrictions tightened, and freedom slipped further away.
Upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No motions, Judge.
Then to the offense as charged in the indictment of burglary of a building, how do you plea?